Welcome to the ultimate guide to estate planning, brought to you by someone who's not an attorney. This is not us practicing law. It's called the unauthorized practice of law. We're not telling you what to do. A lot of the concepts that I'm going to talk to you about, a terminology that no one understands, myself included, we are here to make things simple, to give you information, to give you ammunition so that when you're ready and you're talking to an attorney, an estate planning professional, someone that's setting up a will or a power of attorney, all of those things that you need to know, questions that you need to be asking so that you are able to yourself better understand what you're getting yourself into, who you're talking to, what it is that you have need of, so that you're able to make the best choice. So most importantly, you're able to enjoy your retirement experience. If you're watching this for a friend, for a spouse, for a parent, all of the information is in here to be able to give you ammunition, questions to ask, things to know as you enter into this world that is difficult of estate planning. What is an estate plan and what is it for? Now, I'm going to simplify things. It's to provide direction for your stuff, and we're going to talk about what stuff is, and process by which that direction is able to be facilitated by the people that you trust that are helping you with your estate plan. This applies when you're too sick or what's called incapacitated, you're not able or willing to do things on your own, and after you get your, what I like to call promotion, after you pass away, so that your stuff goes where you want it to go. The key with the estate plan, regardless of how complicated your estate might be, is direction and process while you're alive and where your stuff is going to go afterwards. When you say estate planning, what does estate mean?
In the legal context, an estate means all your stuff. It's everything you own, your home, your clothes, the stuff in your house, your car, your bank account, your retirement account, any account or asset you own is your estate. That's what we mean by estate planning. When people think of an estate, they think of a big house or a mansion on lots of acres behind a big iron fence. And unfortunately, that confuses it with what we mean by estate planning. In the legal context, estate planning and estate is everything you own. That's your car, the stuff in your house or apartment, your bank account, your retirement account, basically everything you own. So if you have a big mansion, that's part of your estate. But if you just have a home that is on 1 acre, that's part of your estate.
So what is estate planning?
Estate planning is a legal process to take care of people and their property when they can't do it themselves, either because they're incapacitated or they're deceased.
And so how does that, tell me how that process works. You gave the example of a child and then an adult. Tell me about that.
Well, once we turn 18, under our system of laws, this is so fundamental that we don't even think about it, but once we turn 18, no one else can make decisions for us. If I'm 17 and I need to go to the doctor and have surgery, the doctor has to ask my parents if he can do the surgery, and they have the right to give legal consent. But once I turn 18, no one else can make my medical, personal, legal, or financial decisions for me, which is what we want when we turn 18. We don't want to be under the thumb of our parents. And as we go through adulthood, this is all great. No one can make our decisions for us. Now, if you're married, you have to consult with your spouse and things like that. So this is good, but it becomes a problem if something bad happens to us. Either there's a bad accident when we're younger, it could be in our 20s, 30s, 40s, or just where we tend to see it is when people become elderly. An 80-year-old may have dementia, they don't know what they own anymore and aren't paying their bills. If they don't have an estate plan in place, that's when the problem occurs, because someone just can't come in and take over their accounts. We don't want anyone to be able to do that. So the law has a set of procedures in place to deal with those problems. And there's one set of procedures that the state puts in place. If there's not an estate plan in place, it's not necessarily the best solution to the problem. So estate planning is you yourself taking the bull by the horns and putting a plan in place to deal with these potential situations that are going to affect all of us one way or the other.
Who needs an estate plan? Everyone already has an estate plan. Even if you have nothing, because the state is going to determine where your stuff is going to go. They have rules already, and if you decide, there's multiple different levels of doing the estate planning. Everyone needs an estate plan, and everyone has one, even if their default is created by the state.
Everyone needs an estate plan at some point in their life. Even an 18-year-old, since once they turn 18, no one else can make their medical decisions for them. They at least need to appoint someone to be their patient advocate. Otherwise, there could be a probate court guardianship. But people are most interested in this usually when they have children, and as they get older, when they've accumulated accounts and assets. People tend to think of estate planning as what happens when I die, which is a big part of it. But the most important part is what happens if I myself am incapacitated and can't make my own decisions, if I can't handle my money or tell the doctor what kind of treatment I need.
If I'm married, can't my spouse just make decisions for me?
Well, if you're married, people may think their spouse is making all their decisions for them. But
it feels like my spouse is making all my decisions
people
for me.
often feel that their spouse is, in some cases, making all their decisions for them. But here's why incapacity is a problem even for married couples. Let's say we have a married couple that bought a home back in the 70s when they were in their 40s or 50s, and now it's 2017, they're in their 80s. One of them has dementia, and let's say it's the husband, and the wife feels they need to move to a retirement community or assisted living. They don't need this big house anymore that they raised their children in. So when they bought the house back in the 70s, both their names are on the deed. When it comes time to sell the house, they both need to be able to sign the deed. The deed is the document that transfers the title of the home to the new buyer. So if the husband has dementia and he doesn't know what's going on, he doesn't have the legal capacity to sign his name, or in some cases people just can't actually sign their name. So in that situation, even though it's a married couple and they own an asset jointly, the wife, if there's not an estate plan in place, the wife might have to go to probate court to get authority to sell their home, which would make a stressful situation even worse and more expensive.
The short answer is everyone already has an estate plan, whether you pick it, you write it up, you create it with an attorney, or you default to the state's estate plan for you. The state has prearranged a method of getting your stuff where it belongs if you're not able to make decisions on your own, and once you pass away, to be able to get it to where their default mode is for it to belong if you haven't done anything in advance. Now, this happens. I would not recommend it at all. It's oftentimes very expensive. It can end up in the wrong hands. It can be expensive to go through the court process. But the answer to the question is, who needs an estate plan? Everyone. No matter if you have a giant estate with all kinds of stuff, multiple homes, multiple businesses, collectors, cars, and all kinds of different stuff, or if you just have this tiny little apartment with maybe a cat and some clothes and some old furniture, everyone needs an estate plan. Let's talk about how an estate planning does what it does to get your stuff where you intend it and why. So here's how it goes. It helps you manage your children's inheritance. You're able to decide who gets what, how they get it. You're able to control for maybe one of your kids or one of your grandkids that has a tendency to spend too quickly, to maybe not make wise choices financially. You're able to set up a plan in advance for them so that it doesn't end up being a hindrance to them. If I have kids, can I just put one of them on the account and tell them to share it with the others?
You could, but that is a potentially dangerous estate plan because once you put someone on your account, they become an owner with you. So all of life's problems that person has can affect your account. If you put your daughter on your account and she gets divorced, that could bring your account into that divorce. Or if she's in a car accident and gets sued and loses the lawsuit, that lawsuit plaintiff could try to garnish your account. Even if those things don't happen, if you just put one of your children on an account and tell them to give it to the other ones, they're not necessarily legally obligated to do that. So
let's talk about challenges that families can face if they don't have an estate plan.
When mom and dad age, if there's not a plan, there's no clear path of who's going to take care of them, who's going to make medical decisions, who has the authority to pay their bills. So there's not a plan. In those situations, it's going to be a more confusing process, a process that takes longer and costs more than if there had been an estate plan in place.
If you're concerned about one of your children getting a divorce, I call it the in-laws becoming the outlaws, you're able to control with a proper estate plan. There are provisions where you're able to control how your assets are set aside for your own bloodline. If one of your children or grandchildren becomes disabled, in your estate plan, you're also able to set up a provision where they are able to qualify for those benefits that they're receiving or might receive in the future to set those assets aside so that they do not count towards other things. This is a tough one. If you have a child that has an addiction or some personal challenges, whether it be drugs or alcohol or gambling, you're able to set up provisions in your estate plan to be sure that it's managed on their behalf for their benefit, so it doesn't become a hindrance to them. Here's one that you would never ever, you come across these every once in a while, but a child passes away, making sure that your children's stuff stays in their respective bloodline, because what if the son-in-law or daughter-in-law remarries, it becomes their assets, and then it would go to their respective bloodline. You can set it up in advance so it goes where you expect it to go and where you want it to go. If you're younger, for younger children, you're able to appoint a guardian to be able to take, that's the person that actually acts on your behalf, that takes care of the children physically, and also a trustee to be able to manage their affairs financially as long as they're a minor, as long as they are under the age of 18. Common misconceptions about estate planning and probate. Here's the biggest misconception, that there's somehow some magic form that applies to everyone and everyone's situation that you can download off of the internet, fill it out real quick, sign your name, get it notarized, and then you've got it and everyone's happy. Now, that does exist. There are places that I've heard of that you can go and get those types of forms, but here's what's at risk. In reality, it must be customized to match not just what's similar about your situation and everyone else, but what's unique about your own situation and everyone else. Your family situation, depending on the age of your children, their ability or likelihood of being able to be responsible, and anything else unique about your family circumstance or your family situation. If you have an adult child whose profession has a likely exposure to lawsuits, you're going to have special provisions in there. You can be able to protect from divorce, the spouse's, remaining spouse's ability to marriage, maybe if you're in a mixed marriage, all of these factors, and I'm bringing these up and you're kind of thinking, well, that doesn't apply, that doesn't apply, that applies. Oh, I didn't even think about that. The reason we're going through this is so that you're able to think about some of the things that you wouldn't necessarily think about. Other areas is your assets, the types of assets that you have, the beneficiary planning. You can't, on the typical beneficiary forms and transfer on deaths, you can't go through all of these types of contingencies that might happen, that in a lot of cases, attorneys that specialize in estate planning have already thought about, and they put provisions. That's why the document is this thick, because they've already figured out ways to be able to be sure that everything is covered. As life transitions, what you want to happen is likely going to be different from other people. You're going to be unique. Everyone is different. In addition, sometimes you're going to want certain individuals to get more money or more stuff or unique stuff that the other people are not going to be able to get. And there's ways to be able to set it up so that no one needs to know exactly who's getting what. With a boilerplate trust or estate plan, typically one of the first requirements is everyone has to get this document, everyone has to know where everything is, and the trustee then is responsible for getting this stuff sent out. Now, you don't have to go to an attorney to get this set up. I would never do that on my own. I'm not an attorney. It doesn't matter to me whether you do or whether you don't. If you want to ask us questions, you can. If you want to call us and say, who do you think we should talk to in our area, in our state, we can give you a referral. If we're comfortable giving you a referral, which we would not give you one if we weren't comfortable with them, you can ask us those questions. We're here for you to be able to answer those questions. So a common misconception seems to be that estate planning is for people who are rich, What does that mean?
Well, yeah, people think of estate planning is for rich people, but estate planning is really just taking care of yourself, the people you care about, and your stuff, your possessions. So that's the biggest misconception about estate planning is maybe that there's one or two trusts or one or two wills, or we can do this online, kind of a one-size-fits-all approach. But estate planning is really depends upon where you are at in life. So someone who is in their late 20s or early 30s, married, and has young children, their estate plan is going to be more concerned about taking care of the children if something happens to the parents while they're young. Someone who is in their 50s at the top of their earning power and they're accumulating assets, they're going to have a different type of estate plan. Their children are older and they've kind of moved past that issue. And then there's estate plans that would apply to someone who's just been diagnosed with dementia, where they're going to be having to be worried about how to pay for long-term care and who's going to take care of their assets and estate for them over a longer period of time. That's what I mean when I say it's not one size fits all.
What is a power of attorney?
A power of attorney is another estate planning document people make. It's primarily designed to manage their assets if they become incapacitated. They appoint someone to sign their name and make financial decisions for them.
What are some common fears about giving someone power of attorney over you?
Well, a few fears people have with powers of attorney are, will the person they appoint know what to do? Because often someone has not handled someone else's finances or money. That's one fear. Another fear is, will the bank or financial institution accept the power of attorney? That's a problem we run into because a power of attorney it's a very powerful document. It's a document where you're appointing someone to handle your assets just like you could, which could include going into the bank and taking all the money out. So banks and financial institutions are wary of if these documents are actually valid when someone comes in with them. Let's say you make a power of attorney in 2017 when you're doing well and fine, and then 20 years later your son or daughter who you appointed to be your agent goes to the bank and says we need to take out half the account for some reason. The banks are worried about, is this power of attorney still in effect? Did you make a different one in between that time? Did you revoke it, or did this person just make it up on their computer? Because it's pretty easy to make documents that look very official.
Okay. So with all the challenges with having a power of attorney and the fears of having one, why not just not have a power of attorney?
The problem with not having a power of attorney is often worse than any issues that would come up if you had one. If there's not a power of attorney in place, the state has a solution for this. This is such a big problem where it happens so often that as people age, they can't make their own decisions due to dementia or just physical illness. So over the years, the state has developed a legal process called conservatorship. So if I can't make my own financial decisions, or let's say my father can't, if I didn't have power of attorney for him, I would have to go to court and file a conservatorship. The drawback to that is it's an ongoing legal process. So first, someone has to file the paperwork to start the conservatorship. Paperwork has to be sent to various family members depending on who the person's relatives are. That's to give everyone who the law defines as an interested party notice so they can come forward and state if they feel the person is or isn't incapacitated, or if they feel they should be the conservator instead of the person who's starting the process. And then it's really going to be up to the judge to decide who they appoint as the conservator. So the person the judge appoints for my father might not be the same person my father would have appointed to make his financial decisions. So if you have a power of attorney, you can make all those decisions in advance. Another drawback to a conservatorship is it's an ongoing legal process. So it continues until the person passes away or recovers, in which case they have to go back and prove to the judge that they're no longer incapacitated. But so long as the conservatorship is in place, whoever the conservator is has to do an annual report every year. They have to show down to the penny every dollar that was received in income, and they also have to document how it was spent down to the penny. So these are complicated, many cases they're complicated documents to produce. There has to be a hearing to approve them, so it can be expensive. People usually need the help of an attorney to help them through this process.
What are some misconceptions that people have about elder law or estate planning?
Maybe that it's one size fits all, or a major misconception is that they don't need an estate plan. So people know that they can designate someone as a beneficiary in their bank account, or they'll put their daughter on their bank account so she can pay their bills if something happens to them. But that's really a very incomplete estate plan, because that person can only handle that particular account.
Are there times when people have an estate plan that they don't even need?
Yes. There are two situations I see where people have an estate plan they don't need. One is they may have an estate plan that's more elaborate than they need based on their current situation. That may be due to changes in tax laws. They have an estate plan that was overbuilt for estate taxes, and that's no longer their problem. Or they may have an estate plan that's too simple. What they have in place is outdated and doesn't address the issues or needs they have now. And they do need something more elaborate than what they have.
Should we be afraid of probate?
You, as the public, maybe should be afraid of probate, but we as attorneys are not afraid of probate. It's a way that we make money over time, helping people settle their estates when they otherwise have failed to plan in advance. If they had planned in advance, often they could have made it so their estate was settled much easier and less expensively. We like to help people settle their estates, but it's not the most efficient way to necessarily settle your estate. If we have a very small estate, there are simple ways maybe to avoid it in many cases. If we have a standard estate or a more elaborate estate, you might need more estate planning to avoid it. So yeah, the drawbacks to probate are it's the state's solution to the problem of someone can't take care of themselves or they're deceased and they haven't made plans to take care of their property.
When someone has an estate plan, are there still problems that they need to be aware of?
Yes, there's a couple areas of problems. One is when you've appointed someone to make decisions for you, maybe it's your successor trustee, often that's someone's adult child and they've never done that before. They have no experience in settling someone's estate. So there's lots of court litigation going on at any time in the probate court, even though someone has a estate plan that was designed to avoid the probate court process because the person they appointed to handle things for them didn't know what they were supposed to do. So where this can be a problem is a couple areas. Sometimes the successor trustee or agent under the power of attorney doesn't have the right disposition or personality or demeanor to do this job, because this is really like a responsibility imposed on this person where they're supposed to act as a fiduciary, meaning they're supposed to act in the best interest on behalf of you and your estate if you're deceased and the people who are supposed to inherit from you. Sometimes we see that when people are appointed in these roles, they sort of think they're the boss and anything they say goes, which is not really the case. It's more like when you go into the bank and you go up to the teller and say, I want to withdraw $500 from my account, they are supposed to do that for you. With the successor trustee, they're supposed to be fair to the other beneficiaries and keep them informed and make prudent decisions. So sometimes trustees don't know that and get themselves in trouble that way. Another area where the successor trustee or someone acting on behalf of an estate can get in trouble is if they don't keep the other beneficiaries informed. The law requires them to report to the other beneficiaries. So if they don't do that, we see a lot of litigation that way too.
The most asked questions about estate planning. Number one, do I need an attorney to help me with my estate plan? And the answer to that question is, you probably should. You probably shouldn't be doing that on your own. You should probably seek counsel. What I would recommend to save time and energy and money is go through, we've got a decent amount of content here that you can go through, that you can take a look at to be able to understand a little bit more of what you know about it. My father would always say, do you understand all you know about it? We've created this resource for you to be able to get information, to be able to be a little more enlightened of layman's terms of estate planning, which really just means stuff, and how you're able to manage that stuff while you're alive and also get it to where you want it to go when you pass away, quickly, easily, efficiently, from a tax and everything else standpoint. Another asked question, can I change my mind afterwards? What if I spend all this money, all this work, all this effort, and then I think, I don't want to do it like that. I want to do it like this. You can change your mind through an amendment to your own estate plan. It's really easy. It's easier than setting it up from the beginning. Do I need an estate plan? That's a frequently asked question. Everyone has an estate plan. The state, your state that you reside in, has predetermined if you don't do anything, if you don't create any legal document, they've already decided who's going to make decisions on your behalf, which is going to be who the judge decides after you go through what's called conservatorship. The judge is going to make the determination of who's best to be making that decision, whether it's a neighbor, whether it's a family member, a son, daughter, whatever the case is, has to go through, and someone has to be able to get conservatorship to make decisions on your behalf. And then estate plan from the state, your stuff is going to go to next of kin minus any creditors or anyone else that believes that they have a reason to have some of your stuff. That's your estate plan. That's automatic by this estate, and no one wants to go out that way. It's best for you to have an estate plan, whether it be through beneficiaries, whether it be through transfer on death, or whether you end up hiring an attorney to be able to put together all of your different assets that you have in your state, all of your stuff, so that it's sure to go where you want it to go. You're able to be tended to while you're living, and as you are unfortunately making the transition, and once you do pass away, I like to say get your promotion going on to where you want it to be. The next question is, how do I find a good attorney? I think this is probably the very best question to ask. How do I know my attorney is a good attorney? How do I know they're qualified to do what it is that I need them to do? How do I know that they specialize in my area of need? And how am I sure that I'm not calling on an advertisement, that I'm actually going to get a person that's doing my work that is the best, and not some brand new person that really doesn't know that much about it, that doesn't really ask the best questions? It's tough. We've provided a checklist, and there's a checklist. We'll make it available to you to be able to ask the right questions of the attorney to increase the odds of you getting the right attorney. And if you would like us to refer someone to you, and there is someone that we know in your area, we will refer them to you so that you are able to find an attorney that we've at least done some background check on, or hopefully have had some extremely good experiences with them. And we can say, yeah, we've had this client, this client, this client, this client. Go to them. They're fantastic. They're very good. And you should have a good experience with them. What's the difference between a will and a trust? Very simply, a will is a public document that when you go through the process after you pass away, everyone can see it. They can see what you've had. They can see who it goes to. It has to go before the court. The judge has to what's called probate the will, which means give time for anyone and everyone to say, well, I think I deserve part of that estate there. I think that he told me that he said he was going to give me that car that he's got. And it's an opportunity for anyone to come in and say, I deserve part of this. A trust, on the other hand, is completely closed off. No one sees it. No one needs to see it unless there's a lawsuit that requires to open up the trust to see everything that's inside of it. No one's going to see your stuff. No one's going to see who's getting it. No one's going to see anything about it. It's all done behind the scenes with a trust. What else do I need to consider? That's my favorite question. Whenever I'm meeting with a professional, I'll ask them, okay, now, thank you for answering all those questions. And being an engineer, I always have a lot of questions. And then my final question is, well, what other questions should I be asking? What other things should I know? And that's why we created this resource through FundMax to be able to give you the ammunition to be able to ask questions, to be able to find out things that you should be knowing, things that you should be curious about, to give you ammunition so that when you are meeting with a professional, or if you're talking to someone at our office, whatever the case is, you're able to get, I'd say you're able to get on the right track of finding what you're looking for and knowing what you're looking for sooner rather than later. These tools are to help you be your own advocate, and of course we're here to be your advocate as well. To be your own advocate in getting what it is that you expect as you're enjoying the freedom in retirement, so you're able to, of course, retire happily ever after. How do you store your estate plan documents? People will say, make sure it's printed on great quality paper so that it doesn't tatter, it doesn't decay over time. Some talk about putting it in form of a PDF or on some type of cloud service. I highly recommend that. And most importantly, keep it electronically and keep it with all of your other stuff. If you get anything from this, you want to write this down. Write down a summary. Have a summary page, a one-page information, just like you do for an executive report. Who's going to be in charge? Who's going to be managing it? Just a brief list of who the attorney was, when's the last time you updated your medical and financial durable powers of attorney, the last time you updated your trust, because what's going to happen is if it's not all organized, they're kind of going through and they say, oh, he made the power of attorney his daughter, 15 years ago. Okay, wait a second. He made the power of attorney his son 7 years ago. And then, oh, wait a second. Here's another power of attorney document where he made the power of attorney document back to her 3 years ago. And here's the irony. Whoever's looking at whatever document, whether it's the first one, the second one, or the third one, how do they know? They don't know that there's any other documents. Do yourself a favor and keep a summary of all of your stuff, all on one page, the last time it was updated, what attorney updated it, the date, who it is, if possible, all condensed into one page. And I would recommend the way we do it with our app, with all of our clients, we keep it on an app on your phone, so you have this is where the whole industry is going, and we keep it on an app on your phone, and you're able to have access to it. And if you want to send it to someone, you can easily send it to someone electronically. Everyone always knows where it is all the time because it's right there for you electronically. The question was how to store your estate plan documents. Don't keep this giant book, that 3-ring binder that someone pulled out this section because they had to get a copy of it, and then someone pulled out. And then I think that maybe it's back at the attorney's office. If you keep it electronically, everyone knows where it is all the time. Keep that summary sheet. Everyone knows where everything stands all the time, especially if your family situation is more complex, if you've got a mixed family, if you have any other atypical uniqueness with your family, you want to be sure you keep it electronically. Everyone knows kind of a broad idea of where you stand, and it's easy to share, it's easy to use, it's easy to implement. Another item that comes up for business owners is how their estate plan fits together with it. The estate plan is what manages your personal interest in your business. Are there tax fees on an estate plan? People will often ask the question, well, what happens? How is all of this stuff taxed? What's the estate tax? First, let's talk about the biggest potential tax is the estate tax and how it applies. If you're married, your estate tax is going to be around assets over $10 million. So if there's over $10 million of family assets, you need to have a plan, and you can have a plan to avoid the estate taxes. If you're single, over $5 million, you need to be managing estate taxes, and they're expensive. The other kind of taxes are income taxes, and those are on assets that have accumulated income. Some of those, many of those are going to be optional of when you pay them, and some of those are going to happen immediately. You can't stop it, you can't change it. There's nothing that you're able to do. The reason we're doing this topic is it is so vitally important. So many times people will come to us after the fact. They've already done a triggering event. They've already initiated what requires all of the taxes to be paid right now. And they come to us and say, well, how do we fix this? And it's too late. Before you do anything, when someone passes away, I'd say call a financial professional, but so many times they don't necessarily know because it's not their area of focus. Call us, contact us, let us know. I've got a specific question. Mother just passed away. We've got all this stuff. We need to know how this is going to be treated from a tax standpoint. In summary, the fear people have about estate taxes, usually they don't apply to you. But income taxes, however, it's literally it's significant. I was going to say life and death financially, but it's huge financially how you pay your income taxes when someone ends up passing away.
What's the difference between life insurance and traditional investing?
There's one key component with life insurance is that the IRS calls it tax-free. just like a Roth IRA, but when you put money into it, once you put it there, it's tax-free, it grows tax-free, it's tax-free forever. Someone is going to get that benefit tax-free because the government says so.
So I have a lot of clients in my 60s who are looking forward to their upcoming minimum distributions they have to take, and they're wondering what are they going to do with all this money they have to take out.
That's a common problem. When you get 70 and a half, you know you're forced to start taking money out and you think, I don't need this money. It's just going to add to my income taxes. What can I do with it? And that's a great example to be utilized for life insurance where you're putting the money in after tax and it comes out tax-free, whether it be for your spouse, whether it be for your children, whether it be for your grandchildren, someone is going to get that money tax-free. In addition, there's types of life insurance today that actually will give you a living benefit.
What do you mean by living benefit?
The living benefit is a rider that's inherent into the life insurance contract. So if you're not able to do 2 activities of daily living, which are the things that would require you to get up and go someplace, getting out of bed, going to the bathroom, eating, bathing, taking medications, changing your clothes, if you're not able to do just 2 of those things, you're able to receive a portion of that tax-free benefit from your life insurance contract to be used at your discretion. You can use it to do whatever you want. It doesn't have to be assisted care. It doesn't have to be long-term care. It can be used for having someone coming into your home and tending to you so that you're able to enjoy the freedoms of staying in your home and be able to utilize some of those retirement assets that you have. How does elder law affect estate planning? And this is in the area of how do I know that I'm talking to the right attorney that's giving me the right advice? Elder law is planning that focuses more on when seniors, as you're aging, are not as easily able to manage their affairs in their infirmities, whether it be physical or whether it be neurological. Elder law focuses on how to pay for assisted care, in-home care, to aid in you being able to get around, to be able to do the activities of daily living. You want to know what these 6 activities of daily living are. And there's bathing, dressing, taking your medications, preparing meals, toileting, transferring, anything that you have from a neurological or a physical standpoint that would be a hindrance to you being able to do the 6 activities of daily living. Elder law attorneys specialize in helping you with those transitions, whether it be medical and financial durable powers of attorney or your estate plan, helping you with that transition while you're alive, having your stuff do what you want it to do, and when you pass away, having your stuff go where you expect it to go. Why do I need a financial power of attorney in my estate plan? Why do I need a medical power of attorney in my estate plan? And it's real simple. When you're younger, and you remember when you were under the age of 18, remember you couldn't do things without your parents having approval, your parents, your guardian, whoever it was, being able to sign on your behalf or act on your behalf. And the same thing happens as you age when you get to a point either physically or neurologically and you're not able to do things. The court in your respective state decides we have to have a plan for someone to have responsibility of making these decisions for this individual. And I'm starting to laugh a little bit, but it's not funny at all, like a child. It's called conservatorship. Someone who has a legal ability to act on your behalf, whether it be financially or whether it be medically, to be able to do what is in your best interest as approved by the court system. They have to go back to court maybe multiple times a year, give an account for every little thing that they're doing, that they're not doing. It is cumbersome. It's a super big deal. And my classic line, it doesn't have to be that way. If you set up your financial and medical durable powers of attorney in advance, you decide who's going to take care of you, you decide who's going to act on your best interest, you decide who's going to execute the directives that you have about your care, and then they're able to just do it. They don't have to go to court. They don't have to answer to anyone. Of course, they're responsible to you to be doing what's in your best interest, but whoever it was that was going to be doing it had to do that anyways. Highly recommend the financial and medical durable powers of attorney. No matter what your age, you could get into an accident, something could happen. You want to be sure that someone's there to be able to act on your behalf. A question that people have is, what's a fiduciary? Are you a fiduciary? Why should I trust you? How do you answer that?
Yeah, so a fiduciary has a couple different meanings, but just in general, it means someone who's required to act on a very high standard in the best interest of someone else. So lawyers are kind of fiduciaries where we have to be loyal to our clients. We have to give our clients all the options and tell them what we think the best recommendation is for them, but the client ultimately gets to decide. So a lawyer has to act in the best interest of their client.
How to prepare funeral expenses and final arrangements, things that you should know, things that you should be tending to make sure that you're not doing incorrect and you're doing the right things. The reason I'm doing this, people ask me, is it okay to prepay? Is it okay to give somebody money, and are they going to actually be there? Are they going to be there in business? Are they going to be there with me when I actually end up needing it many, many years from now, hopefully, when I actually pass away? So here's the thing. You can include directions in your will or in your trust about what type of arrangements very specifically that you want. You can designate a funeral representative, it would be a person, probably a family member, to make those decisions or to carry out the decisions that you've already decided. It's fine if you want to prepay. This is what you want to check on. You want to write this down. You want to ask where the money goes. It should be assigned to a trustee account that's set up on your behalf and the behalf of everyone else that's prepaid, so that if something happens to that institution, to that funeral parlor company, that your money's still there and someone else is able to act on your behalf and do what you were intending on doing, of getting the funeral expenses, the arrangements that you pre-planned done in advance. So what is a living trust?
A living trust is a legal document you make while you're alive to take care of you, your family, and your property if you become incapacitated or pass away.
When is it too late to have a living trust?
Well, it's too late to make one if you're totally incapacitated, like if someone has dementia. The law requires someone to know what they're doing when they make a trust. That's what we call legal capacity. And of course, it's too late to make one if you're deceased.
Okay. If I have a trust and I bring it to you, is it garbage? Am I going to have to start over?
No, not necessarily. We would sit down and have a discussion about what you're trying to accomplish, but in some cases we can do an amendment to the trust, which is just a process where you're changing part of it. Or in other cases, if you have substantial changes, we might do a restatement of the trust, which would be a total replacement, but we're going to be able to use parts of your existing estate plan, even in the worst case scenario. The difference between a revocable trust and an irrevocable trust, the major difference is you can't change as much of the irrevocable trust as you can with the revocable trust. So even though a trust is irrevocable, there's often parts of it that can still be changed. In a revocable trust, that's the type of trust that can be completely changed and completely canceled. There are different types of irrevocable trusts, but they're done for larger estates for estate tax planning, and they're also done a lot for long-term care, nursing home protection planning. The parts of those trusts that typically can be changed is who the trustee is. So if you appoint your son or daughter or a bank and you want to change that in the future, that's something that can be changed in an irrevocable trust. Also in an irrevocable trust, even though assets or accounts have been put into the trust, let's say you have your account with a big financial institution and you want to move it to another, you can still do that. So your assets are not locked in a particular type of ownership. They can be changed within the trust. They just have to remain in the trust in most cases. And finally, another major area of the irrevocable trust that can be changed is who the ultimate beneficiaries are when you pass away. When you create those types of trusts, you often retain the right to change that. So if one child is extremely financially successful, maybe they don't need the money as much, maybe another child isn't in that situation and they need it more, you could make those sorts of adjustments in the future.
Even if you write an irrevocable trust, you still reserve the right to make changes to it even though it's irrevocable.
Correct. In most cases, you're going to be able to change those types of provisions in an irrevocable trust.
That's good. When would you make an irrevocable trust?
These days, mostly in two different situations. One would be if they're concerned about depleting their estate from long-term care or nursing home costs. The law allows people to make what we call a Medicaid asset protection trust, which is an irrevocable trust. You can put some of your assets or accounts into that trust, and if 5 years pass after doing that, those assets are not at risk to having to be spent down to qualify for nursing home benefits. The other broad area is a different situation when someone has a very large estate where they would be subject to estate taxes if they pass away. Typically, for a single person, we're not going to be concerned about that until they're above $5 million or so, and for a married couple above $10 million. But there's different types of irrevocable trusts that can be used there to get assets out of your estate so the government doesn't apply the estate tax to them when you pass away.
So let's get into some of the technicals of different types of planning and the different options that you can create with those different methods.
With the estate plan and long-term care planning, there's a few ways to approach this too. So the ideal way might be in someone's revocable living trust. A problem I see with a lot of these trusts that are drafted by attorneys is it just says that if I become incapacitated, my trustee should use my assets for my health, education, maintenance, and support. Well, often when people are, 85, they're not really concerned about furthering their education at that point if they're incapacitated. So that's kind of a provision that doesn't have a lot of effect. And there's really no definition of what it means to maintain or support someone if they're incapacitated other than just paying their bills. So if I have a client who has followed my advice and looked into getting one of those hybrid or asset-based long-term care policies, often we're not going to have to worry about them depleting their estate on long-term care because they've already taken care of that. So in that case, we would want to include in their living trust, there's going to be a section that describes what the trustee, the person who's acting on their behalf, should do if they're incapacitated. So we would put in there that I've got this policy that can help pay for my care. I don't want you to put me into a nursing home. I don't want to go to a Medicaid nursing home where I have a roommate, someone I've never met before. I want to be taken care of in my home, and you can use this policy to pay for it. We won't have to worry about depleting the estate because it's already taken care of. The trust would also say, because sometimes people, their dementia is so bad where they can't be left alone, or they just need such a medical level of care that they maybe do need to be in some type of long-term care facility. So the trust could be drafted to say, my trustee can admit me to an assisted living facility to help pay for my care or take care of me. But my trustee should make sure I'm being taken care of there. They can use some of these funds from the long-term care policy to maybe hire a nurse to check on me monthly or weekly, whatever the case may be. So one plan might be keep me out of facilities as long as possible, as long as it's reasonable to do that, because I've already taken care of how to pay for it. Another way to approach it is not everyone will want to get one of these policies, or they may not have enough money to do so. So there we have to be more concerned about protecting their estate from a Medicaid spend down. So for a married couple, there are provisions we can build into a living trust to protect maybe half or part of the estate, or maybe more in some cases, for the surviving spouse. It's really technical, so I won't go into lots of detail here, but people should know that a living trust, there are provisions that can be built into it to protect against long-term care.
What are some ways that the trustee or the caretaker for the trust can miss things or make mistakes?
Mistakes that a trustee can make happen often when usually their parent has either become incapacitated and they're for a long period of time and the trustee is paying their bills and handling their money for them, or they're trying to settle the estate when they pass away. So unfortunately, there are lots of probate litigation cases that occur all the time when a trustee doesn't do their job well. When someone has a trust and they have become incapacitated or pass away, the trustee becomes a fiduciary, which means they have to act in the best interest of the trust and the people who are involved in the trust. So some people just don't have that personality. That means being a fiduciary means they're supposed to be reasonable. They're supposed to learn about the ramifications of a decision before they make it, not act hastily or act impulsively. and it means they're supposed to be fair. So sometimes people have a personality where they think the trustee, being the trustee, means that they're totally in charge and they don't have to listen to anyone else and they can act on their own timetable. But when someone's a trustee, the law generally requires them to settle the trust in a reasonable amount of time, make prudent decisions. So that means they can't sell the property up north to themselves for $50 when it's worth $200,000 and things like that. And it also means they have to keep the other beneficiaries informed about what's going on in the estate. They have to do a report. So even though we're not in court, in a probate court, settling an estate there, the trustee still has legal responsibilities they need to follow that often they're not aware of because there's not a court involved telling them that.
Mm-hmm. What's the difference between an attorney who can do a will or can do a trust and they do it every single day or they specialize in it?
The difference between an attorney who just dabbles in estate planning or specializes or focuses in it is big. As an attorney, once I passed the bar, I could handle a murder trial this week, a big business litigation lawsuit next week, and then I could do your trust the following week. But that's not really going to produce the best result because each area of law has become so specialized and focused. Someone needs to spend most of their time counseling people in these areas and staying up on the law. Every week there's new case law issued and written reports that we need to study to see how the courts are interpreting the laws the state legislature has passed in probate and taxes and long-term care and incapacity planning. So if an attorney is focused on estate planning where they're doing elder law and estate planning every day, they're going to know how to apply all this experience to your situation. So it's kind of like going to a doctor who's been practicing for 10 or 20 years. They're going to be able to make a diagnosis that's accurate much faster than someone who's a generalist or just getting started in it.
What do I need life insurance for at this age? Are you kidding me? I'm done working. Life insurance, estate planning? That's right. In estate planning, life insurance can be one of the most powerful tools in managing your income taxes, in you being able to get benefits while you're alive as you make the transition of having any type of challenges physically or neurologically. You're able to get those benefits through very specific types of life insurance products. I'm going to talk about one. It's called corporate design life insurance. As retirees age, when you're forced to take out required minimum distributions out of your IRA, you don't need the money, you must pay the taxes on it. Where do you put it if you don't need it, so that you're able to get the highest tax advantage for yourself, for your spouse, and for your heirs? You can utilize a certain type of life insurance for your benefit. So if you ever have any type of need for even in-home care where you're not able to do 2 activities of daily living, and I'm going to go through what those 2 activities of daily living are: bathing, dressing, taking medications, meal prep, toileting, and transferring. Basically, if you were going to go someplace, all the things that would be required for you to get up, clean yourself, get ready, have a meal, and get there. If you're not able to do 2 activities of daily living because of some neurological or physical challenge that you have, you're able to get tax-free benefits. Another attribute of life insurance is when you're passing your stuff on to your spouse or to the next generation, avoiding or managing income taxes. Because life insurance is tax-free, anything that goes through that mechanism is going to be able to come out completely tax-free. So if you have a large estate or a farm or different things that would be difficult, a business that would be difficult to liquidate, you use life insurance to be able to pass those assets on to the next generation. Anything that you have extra in a category that I would call discretionary assets, life insurance is something that at the very minimum you should consider. And when you're even thinking about that, if you haven't had any major things happen in the last 5 to 10 years, you're likely a candidate for life insurance. Major things. It's changed so much over the course of the years. Today, in estate planning, life insurance is used for managing income taxes, transferring assets, and most importantly to you, giving you benefits while you're alive so you're able to do the things that you want to do, have assistance in your home, money tax-free that you're able to use at your... I feel like I sound like an infomercial, but I am excited about it because so many financial professionals don't understand it, they don't know how to use it, they don't know how to apply it, and that's why we made this video, so you know to be asking a question. You can call us, you can ask us. It is something that we do specialize in, and we can tell you quickly if you're a candidate for it and if it might even be a good idea, or if we would say, well, you got this and you got this, and with your state, probably not. It's a good idea, but for you, I don't know that would be as good of a choice. I think we might recommend maybe doing this, or just keep doing what you're doing. Give us a call, ask us, watch other videos, whatever you want to do. We're here for you. The life insurance talk here is just to make you aware of some things that, really, there's very few people that are aware of it. What about life insurance with estate planning?
Life insurance is important in estate planning and is used frequently to leverage your estate to leave more to your heirs in a more tax-efficient way and in a more protected way.
Does it cost you like on a monthly basis or an annual basis to be able to do that, or how do you pay for it?
No, if you're doing an estate plan and coordinating your life insurance with it, there's not going to be ongoing fees. It's just going to be part of the one-time estate planning fee.
Are there ways to use life insurance and be able to control how it's distributed after you pass away?
Yes. One, you can make your living trust the beneficiary of the life insurance, and you can put in the trust that it would go to, your children or your grandchildren over time. For like grandchildren, you could specify that it's used for their education and even put incentives in if they go to college and, graduate about when they should, that they would receive some of the funds at that point. So there's lots of ways life insurance can be used to help your family after you're gone from everything you saved and worked for during your life.
What's another reason you could use life insurance for passing on assets?
Well, one of the things that we need to think about with life insurance is a lot of my clients who are in their 50s, 60s, or 70s have a pension, and their adult children are not going to have a pension. Even though they've worked hard and they've been smart and gone to college, just a lot of companies are not offering pensions anymore. So, and we also have to be concerned about what's going to happen with Social Security. So this may not be a concern for you, but it may be a concern for your middle-aged child or your child who's going to be middle-aged or elderly 10, 20, 30, 40 years from now. What kind of retirement income are they going to have? So you can leave life insurance and trust for your children to provide a retirement income in case they don't have a pension or they don't have Social Security benefits that are as good as yours, because we don't know what's happening other than there's lots of changes in society that are impacting people's employment and the amount they can earn. We see automation increasing that's taking away jobs, globalization, and those trends are just going to continue. So people who have assets and who have saved can use life insurance as part of their estate plan to create that retirement income for their children that they enjoy that their children may not have themselves.
Yeah. What do you do for planning in advance of a potential long-term care expense?
There's three general approaches you can take to plan in advance. One is people can purchase traditional long-term care insurance. This is a product that's not very popular because it's expensive, and in general, people don't want to purchase a policy to pay for a place that they never want to go to. No one wants to go to the nursing home. So we're seeing traditional long-term care insurance it's never been utilized much, and it seems to be becoming less popular. A newer alternative that is a lot better, in my opinion, is what we call a hybrid long-term care policy or asset-based long-term care policy. The advantages to these policies are it's a tax-free way to structure part of your assets to stay at home and pay for care at home instead of having to move to a facility. But if you do have to go to a assisted living or nursing home, having this type of policy in place can provide substantial long-term care benefits to help pay for it, so you might not ever have to deplete your estate, or you might not ever have to worry about trying to qualify for Medicaid. Another good thing about these newer hybrid or asset-based policies is if you never use it, if you never need long-term care, your heirs get a death benefit, so you're not wasting the money like with the traditional policy. if people are interested in these things, unfortunately, there's not a lot of advisors who are knowledgeable about them. A lot of financial advisors are just concerned about structuring someone's assets in the stock market, and they just sort of assume you're going to be fine forever and you'll pass away at some point. They're not thinking about there can be a long period where someone needs long-term care. If I have a client who has, all my clients who are planning ahead, we would like them to look into this. I refer them to an appropriate financial advisor who's knowledgeable about these policies.
Everyone needs an estate plan, and everyone has one, even if their default is created by the state. The default plan is what's called, you might want to write this down, you don't need to, but it's intestate, which means you're dying without an estate plan. You're dying without any type of directions. You don't have a will, you don't have a trust, and no one knows exactly where to go, so you have to go to the court, you have to have someone that's representing you and take you through the probate process to decide where your assets are going to go, who's the next of kin, who are your creditors, and where is all of your stuff going to go in the future. The next method is do it yourself or just a beneficiary. And if you have a investment account or an IRA or life insurance, they would ask you, who do you want your beneficiaries to be? How do you want to split them up? Your primary beneficiary, your contingent beneficiary. The contingent is if the primary beneficiary is not there and able to take your stuff, where it's going to afterwards. And then also a do-it-yourselfer is, you're probably familiar with this, transfer on death. When you pass away, who does it then end up going to? Who gets your stuff after you pass away? Those two things you can do on your own. You generally don't need any help from any type of professional, although this isn't me telling you what to do again. This is not me giving you advice. The next type of a estate plan, very minimal, is a durable power of attorney. And you may ask what the word durable means. It means to continue after you are incapacitated, whether physically or neurologically. You're not able to do things on your own. You're either unwilling or unable. The durable power of attorney grants the authority to someone else, someone you trust, someone you pick, to manage your affairs on your behalf. With the durable power of attorney, there's two types. One is medical and one is financial, and they should be separate. You may want separate people to handle those. You may want them to be the same person. They don't need to be the same. The reason you want your medical and financial durable powers of attorney drawn up by an attorney is because it is an extremely powerful document. It grants authority for someone to literally act as if they were you, to make all decisions on your behalf. So it should contain directions, safeguards, and the person who you appoint, which is the technical term, is the agent. It gives them that authority to manage your property as you see fit. And some would say, can I just do that on my own? Can I get the form online on my own? And the answer to that is, I'm told, although I have never done it, yes, you can, but I would not recommend doing that. Can you imagine just signing some form and giving someone complete authority over everything about you, medically and financially? It just doesn't sound safe to me. So I'm not an attorney, of course I'm not going to draw it up, neither would our office, but I would recommend having the experts do what the experts do. The attorney can make it so the provisions actually apply to your own situation, to the state formalities that you have, that it's up to date. In addition, if you do it yourself, oftentimes the bank or the institution might look at this and think, this is a little risky here. I don't see any other legal person involved. For your protection, maybe we won't accept this. So you have to go through their legal department. If you have your durable and financial powers of attorney set up in your estate plan and your beneficiaries, all of those things, you say, I already did that. I did that years ago. You want to write this down. Every 5 years, you should have it all reviewed to be sure that it's up to date with current law. If you have anything that changes in your family situation, in your health situation, or in your wealth situation, you want to be reviewing your documents to be sure that everything is up to date. And the easiest way is to have an attorney look at that or someone that's skilled in that area. The cost. People ask the cost. It could be anywhere from $75 to $1,000, but generally it's between $350 and $650 to have an attorney draw it up, the powers of attorney, the medical and financial durable powers of attorney, and to have it reviewed, typically 1 to 2 hours of whatever their time cost, they're able to do that. Let's talk about a will. Oftentimes people will talk about their last will and testament. I've already got a will, and what that means. Your will is what says this is where my stuff, my estate, my assets, my accounts, everything, it's where it goes when I pass away. To be able to finish the will, it has to go before a judge, it has to go through probate, and all of these potential creditors, family members, friends, anyone that might think that they should have something from you or from your estate, that's their opportunity to go before the judge and say, where's mine? Where's my stuff? I want to get my stuff from this now. It has to go through the probate process, which means to prove, and that takes months. Let's talk about trust, the different types of trust. Generally speaking, the trust that you hear about most is the revocable trust, and that's set up to contain, to manage, and to direct your assets, your accounts, all of your stuff, so that it's able to be managed for you on your behalf and be passed on to the next generation or wherever it is that you want to pass it. The other type of trust is an irrevocable trust. An irrevocable means there's aspects of it that cannot be changed at all, ever. But one thing to point out is that oftentimes there's options that you have with an irrevocable trust, if it's written correctly, that you can make significant modifications for your benefit because it's your stuff. The next type of trust is the IRA Trust, and that is able to manage your IRAs to be able to continue the tax deferral for your children or for your grandchildren. If you have any type of special needs or special circumstances or a family situation that you need to protect from, you can utilize the IRA Trust. A special needs trust. If you have special needs, you know what this is. It's if you have a family situation where you need a document that's created so that your family member or friend or whoever it is able to continue to get benefits that they would get by putting those assets into the special needs trust. And finally, of the most typical trust, and these are just the most typical, is a Medicaid trust. This is an area where you're able to utilize to be able to protect your assets if you go into a nursing home, when you're in a nursing home, if you're already in the nursing home, to be able to set them aside for you, for your benefit, for your heirs, while you qualify for aid from the government. That's a little bit long, but it's a summary on an estate plan, and it's really a good summary of all of the things that you would be considering generally in setting up an estate plan to get your stuff where it belongs while you're living, and also get your stuff where it belongs when you pass away. What if you need to adjust your estate planning goals, your needs change? What do you do now? Here's the obvious. If you have a change in your family situation, your health situation, or wealth, I always say family, health, or wealth, you want to be looking at your estate plan to see if something needs to be tended to, and my recommendation is to go to an attorney, the one that drew it up, and have them take a look at it, because they're going to be much more aware, even than what we are, of all of the things that go into it. When you set up, if you do change your estate planning goals and you say, well, my one son has way more money than what he's ever going to need, and my other son, I ended up lending some money to him for a down payment on his house. I want to be able to give my daughter more money than what I'm giving my son that has more, and the one that I rented gave money to. You can set that up, and whoever is the trustee, you can set it up so that whoever is the trustee is the only one that's privy to all of that information. The reason this may be important to you is because if everybody says, well, why is he getting that? Well, why is he getting that? Well, and they don't necessarily know the whole story, it might cause contention, and no one wants to look down and think, oh my gosh, now they're fighting like they did when they were 6, okay? So you want to make sure that all of this is set up so that you're able to manage it, the stuff goes where you want it to go, and you're able to keep peace in the house as much as possible. After I put everything into my trust, I fund my trust and get it all done, and I want to change my mind. Can I change my mind and start over?
Yes, you can always change the trust. The trusts are called revocable living trusts, which means you as the creator of the trust can change it. You can take property out, you can add other property to it, you can change who is going to make decisions for you if you can't make them yourself, and you can also change who's going to inherit your property after you're gone.
Perfect. People try to do the right thing by setting up a trust. Is that all they need to do then?
No, when people set up a trust, there are still things that are going to need to be done. First, while they're alive, they need to make sure that they align their financial plan with their estate plan. What I mean by that is, at a fundamental level, they need to make sure that they have a financial plan in place. You can have the world's best estate plan, but if you lose all your money the next time the stock market crashes, you didn't maybe really need that estate plan after all. So aligning the financial plan with the estate plan means maybe meeting with a financial advisor to make sure that you have your assets structured properly based on your age and where you're at in life and your goals. And then it also means making sure that your assets and accounts are coordinated with the trust. So some assets will be retitled into a home, like the real estate with a deed. Some cases, beneficiary designations for retirement accounts, annuities, and life insurance would need to be updated. So that would be the overall part of aligning the financial plan with the estate plan.
That's good. Summary and what's next. So we provide all this information through FundMax. You're able to ask questions. You're able to go through and watch videos, read some things, whatever it is that you are doing. What do we do now? You can contact us, and I would prefer you go through lots of material on the site so you kind of get an idea of our style. You kind of can likely get a lot of your questions answered, and if you still want to talk to us, please do. You're welcome to contact us. You can instant message us, you can email us, you can give us a call, and we will go through the process of answering some of your questions. If you're looking for a referral from another professional, whether it be tax or legal professional, if we're comfortable referring someone, if we've had good experience with them, with other clients that have worked with them, we will give you that referral. We will give you their information of who to contact. And I will tell you, if we're not comfortable referring anyone, we're not going to refer someone to you. We will tell you, if you're more curious about questions that you should be asking, things that you should know, you can contact us. We will be there for you. And I'm going to go all the way back to the beginning of why we do this. When I first started in the financial services business, being an engineer, as I am, you never stop being an engineer, I developed a process by which I could teach, by which I could educate people, by which I could be there with people to be able to give them information about what they have, feedback on what they have, and how it's aligned with what's most important to them. And I've done that as a public service for groups of people. And now, as you see it, which has been for some time now, through videos where anyone can watch it, share it, rewatch it, all of those things, this is a resource for you, for your benefit. We are a financial firm that makes money. We are a financial firm that takes new clients. We are a financial firm that holds ourselves as a resource to the public to be able to give them information, to be able to give them detail that I just haven't seen anyone doing, because they always want to close the business, get the client, get all this and get all that. And for us, it's we give something away, give it away, give it away, give it away, because oftentimes, especially if you're a do-it-yourselfer or if you feel like you're all set, you feel like you're well tended to, it can be intimidating. You can feel like, I don't want to feel like someone's trying to sell me something, and we don't do any of that. We're here for you as a resource, even though we get lots of clients from this. Of course we do. When you're out like we are, and you're getting all these views and having all these people come to our website and they're sharing it, of course we're going to get clients from it, but it doesn't have to be you. Thank you so much for watching, for sharing, for engaging, for benefiting. It's all for you. Thank you so much. You may need us, you may not. You may have come here and you got all the information that you need, and you have this little bit of you that kind of thinks, I feel a little guilty because I got all this stuff from them and I gave them nothing. Well, share it. Send it to somebody that you want to. Share it with somebody, or don't. If you don't feel comfortable sharing it, don't share it. We're here for you. We are here for your benefit. Suck us dry of everything that we have that we might be able to teach you, and we'll be here still serving you and giving you information. One thing to point out, this is evergreen content. It's changing and changing and changing. It's staying current. If there's a message that we're communicating that you think, I don't get that at all, you need to be more clear, let us know. And likely, as we have many different times, we'll adjust the video, maybe adjust some of the content so that it's able to be more clear for you. In addition, if you have other questions that you would like to have answered that you think others might benefit from as well, contact us and let us know, and we will likely create a method to be able to answer those questions as well. You're probably not the only one with that question. Thank you so much.